Thank you and welcome, friends, and thank you so much for being here. We have today some experienced and very capable judges hearing argument. And we have some outstanding lawyers who are going to be making the arguments. And we have some very interesting Montana-based issues that are being heard. So you have chosen very well to spend some time with us this morning, and again, thank you for being here. So some might wonder, well, where does the Ninth Circuit usually sit? And I want to let you know that they meet monthly in 3 places, in Seattle, San Francisco, and Pasadena. They meet 6 times a year in Portland, in Portland, 3 times a year in Honolulu, and 2 times a year in Anchorage. And then from time to time, these special sittings in other jurisdictions, other places.
What difference does it make that it's a huge company?
I think the difference has to do in part with the fact some of the public policy considerations that Judge Christensen was concerned about.
The union contract, or as you said, some other kind of a contract that obligated the employer or former employer to rehire him or her, that's one thing.
Correct.
But I don't see where your client had that. Can you help me out?
Sure. The Supreme Court says that that duty to rehire exists when an employer, either through regulations, if it's a government employee, or through personnel policies, creates that obligation. That obligation to not discharge someone except for good cause.
What's your best Montana case that fits this factual circumstance that says someone who's prevailed in a wrongful termination case, that mere fact imposes a duty on the former employer to rehire? It would require some interpretation. I mean, it would be one thing if you had a Montana Supreme Court case decided within the last couple of years that fit your facts, that said under these circumstances, Costco had a duty, or an employer in Costco's position would have a duty to rehire. You've told us there is no such case. It's an open question. Our choice is either to try to interpret the Montana statute or ask the Montana Supreme Court, what do you think?
What I said was there is no case specifically on point with a, although under the WDA, although actually there is, you're on that particular case, same situation, personnel policies that required that a permanent employee not be terminated without just cause.
And you would have to concede that you have to have a duty to rehire before this provision of the statute's triggered, right?
Correct, Your Honor, but my point is that...
So where's the duty in the policy?
The court makes a statement near the end that his ruling is consistent with Montana's public policy as it's embedded in the statute.
What's your strongest argument that failure to recall or rehire does not encompass the situation this particular case presents?
And the Montana Supreme Court in 2 cases, I believe, has addressed exactly this. The first is in the Kneeling case, under facts that I think are quite similar to those before the court.